Uh, Good morning, everyone. On behalf of organizing committee, I warmly welcome you all to the sixth TGA Virtual Mood Court Competition 2025 conducted by Thomas George and Associates. I am Vaishnavi Upadhyay and I will be acting as your court master for today. Before we begin, I request all the participants to keep your cameras on throughout the proceedings and kindly ensure that any technical issues are communicated immediately through the chat box. For today's round, we are honored to have Miss Vidya Vincent and Advocate Shreya Vijayakumar as our esteemed judges to adjudicate this round. And we extend our warm welcome to your ladyships for taking out their time from their busy schedule. Thank you, ma'am. With now, we starting with the introduction of judges. Miss Vidya Vincent is LLM second rank holder from Kannur University, Kerala, and has 5 years of experience as a permanent assistant professor. Moreover, 10 years of experience as a practicing advocate and researcher scholar at the School of Legal Studies, CMR University, Bangalore. Additionally, she has practiced in and secured position in several international and national level moot court competitions held throughout the India. She has published various articles in international and national journals. Additionally, she has presented a research paper at several international and national conferences held across India. Advocate Shreya Vijayakumar is currently associated with the legal profession through her work in litigation, where she has drafted, filed, and argued a variety of matters before the subordinate courts and the high courts of Telangana. She has gained substantial experience working with the leading law firms, including Tri Legal, Singhania and Partners, AAN Legal, and other notable chambers on matter of spanning. Uh, she has built a strong foundation in the courtroom advocacy through her extensive involvement in several prestigious competitions, including the Symbiosis Trial Advocacy Competition, the Kerala Law Academy Moot, and the NMIMS National Trial Advocacy Competition. Her broad exposure to litigation practice, coupled with her active engagement in national level moot courts and trial competition, bringing both depth and precision to her educatory approach. Now I would like Avni to introduce the rules.
With the permission of bench, I will proceed with the rules of this session. In case of internet connectivity issue resulting in interruptions, a maximum extension of 5 minutes may be granted. Each speaker will be allotted 15 minutes. We respectfully ask the bench to kindly not grant any extension due to paucity of time. The structure of proceeding will be follows. Counsel 1 and Counsel 2 of appellant will be present their case first. This will followed by the Counsel 1 and Counsel 2 of respondent. All participants are reminded to maintain a good and stable internet connection and ensure that your cameras remain throughout the rounds. And the judgment may be screen shared only with prior permission of the bench. Before we begin the round, please note that time will be strictly monitored to ensure the smooth conduction of this session. I will inform both the sides through the chat box when there are 3 minutes left, 1 minute left, and 15-minute ends. With the kind permission of the bench, the court is now in session.
Yeah,
I wish all the teams best of luck.
I think we can start now. Vidya ma'am, would you?
yeah, we can start.
The council seeks permission to address the dais.
Yeah, of course.
It is most humbly submitted that the petitioner has approached the Honorable Supreme Court of Union of Indigo under Section 62 of the Insolvency Bankruptcy Code 2016 The petitioner most humbly and respectfully submits before the jurisdiction of the present court and accept that it has the power and authority to preside over the present case. If the bench is satisfied, the counsel seeks permission to go on with the statement of
Yeah, of
facts.
course.
Much obliged, leadership. ABC Bank is a financial creditor who sanctioned rupees 500 crores to XYZ Private Limited, who is the corporate debtor in this case. Who defaulted on repayments and the debt was classified as non-performing asset on 1st April of 2014. Now, XYZ Private Limited acknowledged the debt via restructuring request and with OTS proposals, that is the one-time settlement proposals, which was sanctioned on the 1st February of 2020. However, was cancelled due to non-repayment. Now, we all know that in the year 2020, there was an outbreak of the COVID-19 pandemic. And due to this, there was an enactment, Section 10A in the Insolvency and Bankruptcy Code 2016, which was a statutory bar on the filing of any application, which was for initiation of the CARP process, that is the Corporate Insolvency Resolution process. The first application under Section 7 of the IBC was filed on 1st February of 2022, where the default date was mentioned as 1st May of 2020 and was dismissed based on the Section 10A's bar. And the second application was filed on 2024, which corrected the default date to 1st April of 2014, but was dismissed citing res judicata and invalid date changes. Now, our client has now approached the Supreme Court challenging these dismissals. If the bench is satisfied, the counsel seeks move on with the statement of issues.
Of course.
Much obliged, leadership. Now, issue 1, whether or not a second application under section 7 of the Insolvency Bankruptcy Code 2016 is barred by law. And issue 2 is whether or not mentioning of the date of default is mandatory in applications under IBC. And issue 3 is whether or not the date of default changes based on facts and circumstances, or is it taken to be as the date of non-performing asset in all bank matters. And issue 4 is whether or not a case can be admitted if the default has occurred and the application is within the limitation, despite an error in the date of default. Now, if the bench is satisfied, the counsel seeks permission to move on with the arguments advanced.
Of course, you can.
Much obliged. May it please your leadership, the issue is whether the second application under section 7 is barred by law, which I submitted is not. The earlier application was dismissed only due to the temporary moratorium under section 10A and not on the merits of the debt or the default. Hence, the res judicata does not apply here. Not only the earlier error was only of technical in nature, as the default date was misstated as May 2020 when the one-time settlement was cancelled. Whereas the actual default arose on 1st April 2014 when the account was declared as non-performing asset. The debt remains undisputed, the default yet continues, and the creditor's right to seek corporate insolvency resolution process yet subsists. May please your leadership that in the case of Innovative Industries versus ICICI Bank, the court has held that when the first application suffers from procedural defects and is dismissed without final adjudication, the financial creditor may rectify those defects and maintain a fresh petition. Further, that
Through what counsel? How do you file a fresh application in the court? Like, how did in the case, how did they file a fresh application? You said they can fix the defects and then approach the court, right? Through how?
Through filing another fresh petition, Your Lordship.
You can just go to the court and file another fresh petition?
I mean, we know if there is an error in the first application, the NCL, that is the National Companies Law Tribunal, will give 7 days time to rectify those defects.
Right. What do you call it when you put it in CPC? Simple.
Your Lordship?
Amendment of pleadings? Amendment of pleadings? Is that what the case, is that what they did in the case as well? Did they amend the pleadings and then file it fresh?
Yes, Your Lordship.
Yeah. that's what I was looking for. Okay.
Much
Good.
obliged.
Continue, counsel.
Yes. Much obliged, Your Lordship. Further, the law clarifies that failure of one-time settlement does not change the date of default, and repeated acknowledgements by the debtor extend the limitation period. Thus, the second application is well within the law and maintainable. Therefore, the second application is not a repetition of the first, but a fresh application correcting a clerical mistake and is filed within limitation. To deny admission would elevate form over substance and defeat the very purpose of the court. If the bench is satisfied, the counsel seeks permission to move on with the next issue.
Yeah, of course.
Much obliged. Now, the issue at hand is whether or not mentioning of date of defaults is mandatory in applications under the Insolvency Bankruptcy Code 2016. Your Ladyship, Section 7, subclause 3 of A of the Insolvency Bankruptcy Code requires the financial creditor to submit records of default along with the application. This provision is directory, meaning it is meant to facilitate the effective processing of the process rather than not to defeat claims on technicalities. In the case, the corporate debtor's default on 1st April of 2014 is clearly established by the classification as the debt as non-performing asset by the bank, which is sufficient proof of default for the purpose of Section 7. In the case of Razan Bulan Sugar Company versus Municipal Board, the court held that whether shall is mandatory or directory depends on the object of the provision. Here, the Section 7, subclause 3 of A is directory as it guides the manner of proving default to establish that a default has occurred. Not only that, the Supreme Court in the case of Indian Overseas Bank versus RCM Infrastructure Limited held that the default is a factual event and the application cannot be rejected for procedural omissions. The error in mentioning of the default is purely procedural and purely rectifiable. Therefore, the application must be allowed after rectification as the substantive requirements of debt and default are clearly met. If the bench is satisfied, I would like to call upon my co-counsel to deal with the remaining issues.
Counsel, my question is that what's the impact of Section 10A on the maintainability of insolvency application? What's the impact of 10A, Section 10A, on the maintainability of insolvency application?
Section 10A was enacted to unburden the courts from backlog of cases during a certain period. That is from 25th March of 2020 till extension up to 1 year. So the debts that are occurring during that period are not maintainable in the court. However, the previous defaults, that is in previous to the date established, are still maintainable in courts, Your Ladyship.
Okay.
Much obliged.
You may proceed. Okay. Next, counsel.
The counsel seeks permission to proceed with the arguments. The issue number 3.
Yeah, go ahead.
The issue in 3 is whether or not the date of default changes based on facts and circumstances, or is it to be taken as the date of NPA in all bank matters. Your Ladyship, in this matter, I would say that the date of default is to be determined by the date of NPA, because the date of NPA is the declaration given by the bank where the initial default raises. So I would state that the date of default should be determined by the date of NPA. For supporting this, I would like to state a case law, Lakshmipat Surana versus Union of India, where it has been held that the date of default is taken to enable the financial creditor to initiate the proceedings under Section 7 of IBC, which clearly gives a place for a date of NPA to be the date of default in proceedings under Section 7 of IBC, Your Ladyship. And here in this case, the original date of default is 1/4/2014, on which the account has been declared as NPA by the bank. But in the first application, which was initially filed by the applicant, it has been stated the date 1/5/2020, which is not the initial date of default.
In the case of Jagadish Prasad Sharda versus Allahabad Bank, it's been held that the date of declaration of NPA is the date of default, and such date of default will not shift even if a subsequent payment is made by the corporate debtor. Here, I would like to clear a point that a first application has been made with an error and it has been rectified in the second application. And in the second application, it has been rectified as the date of 1/4/2014, which is the initial cause of default, that is the date of NPA. Here arises a genuine reason for the second application and makes the second application maintainable under Section 7 of IBC. And in the case of Dena Bank versus C. Shivakumar Reddy, it is also be supported that the fresh cause of action will give an opportunity for the second application under Section 7 of IBC. And here, I would also like to clear the point of limitation, which is also satisfied under Section 18 of the Limitation Act 1963 by the continuous OTS proposals. And the OTS proposals were also be considered as the acknowledgement of the debt and valid under Section 18 of the Limitation Act 1963, which is supported in the case Tejas Kanda versus Bank of Baroda. Your Ladyship, by the facts which I stated above, I would like to conclude that the date of default should be determined by the date of declaration of account as an NPA, the date which is declared as an NPA by the bank matters. Here, the second application by the applicant has been rightly held by pointing out the initial date of default. Hence, on the basis of this, the second application dismissal by the NCLT should not be entertained, and the date of default, and the date of NPA should be considered as the date of default in the matter, in the all bank matters. Your Ladyship, if satisfied with the third issue, the council seeks to.
Is the date of default bound to change anytime? How is this date of default bounded from changing over time?
The date of default can be changed, Your Ladyship. It also been supported in the case of Axis Bank Ltd versus Yashwant Bagraj Ltd. In that case, it has been held that even after proceedings has been closed, an amendment can be made in the date of default, and it can be proceeded with a fresh application.
Okay.
Council, my question is that in what manner do one-time settlement proposals impact limitation under IBC?
Your Ladyship, the one-time proposals is an acknowledgement because the debtor is asking for an one-time settlement of the debt, which obviously creates the extension of the payment, which clearly indicates that the extension of the time period obviously refreshes the limitation and falls under the limitation, Your Lordship.
Okay, you are actually council number two, council number 2, council number 6 and council number 2, right? Okay.
May I proceed with the issue 4, Your Lordship?
Yeah, of course.
Yeah.
Issue 4 is that whether or not a case can be admitted if the default has occurred and the application is within limitation despite an error in the date of default. Your Lordship, before proceeding with the answer, I would like to clarify the limitation and the occurrence of the default in this case, Your Lordship. Here, the limitation, as said in the previous issue, it is satisfied by the OTS proposals. And the occurrence of default is also satisfied by the date of, by the declaration of NPA by the bank matters. By this facts, we can conclude that there is an occurrence of default and there is unfulfillment of limitation.
What
Your
provision of
Lordship.
the Limitation Act is attracted here in this case? As you claim,
Section 18, Your Lordship,
and
which
any
extends the
article of
time
schedule?
period. Article 137 of the Limitation Act.
Right. Okay, thank you.
Proceed.
Yes, Your Lordship. By this, the occurrence has been cleared. And coming to the error of the date of default, the error on the date of default is not in uh, a fact in law, your lordship. It's an procedural error which is a curable defect and which can be rectified. Due just because the date of default is in error, an application can't be rejected, your lordship. And it is also supported by the same case law, Axis Bank Ltd versus Yashwant Patreja Ltd, where it allows the second application even the first application is closed due to even the first application is closed due to an error, and the second opportunity has been given after closing of the proceedings due to a genuine reason, your lordship. I think here the applicant has a genuine reason that the initial default has occurred from the 2014, not in the year of 2020.
Does the provision
So
provide for good cause as a reason or a backing to pardon the delay? Is the provision clear on that?
I'm not sure, your lordship.
Is the provision saying that a good reason or a good cause is sufficient for a delay, as you
I'm not
claim?
well about. I'm not well about. I'm not well aware about that.
No, because you mentioned it's a good enough reason for the delay, right? So, like, on what basis?
On
Good enough
on the
reason for
basis of
of what?
On the basis of the case laws, I have stated that, Lordship. I'm not sure about the provisions. As we discussed the issue 3 in Denna Bank versus Shivakumar Reddy versus another, the second application has been allowed due to a genuine reason, Your Lordship, which is an arisal of a fresh cause of action. Here is also there is a genuine reason because the initial it is being proven by the NPA date declaration that the initial default has been occurred in the year of 2014, not in the year of 2020.
But what's the genuine reason?
Yes, yes, Your Lordship.
What is the genuine reason?
The genuine reason is the declaration of NPA on the date of 2014. It is a genuine reason, Your Lordship, because it
Is it
evidently
the
proves.
is it the same vice versa in the Dina Ban case?
Dina Bank case, it has been given on the basis of fresh cause of action.
So, don't you think when a case laws, facts, and the whole background is different, a good enough reason would not suffice citing that case in this case, in this matter?
Your Lordship, the core point I would like to convey here is there has been a reason that a fresh cause of action, which is a genuine reason, which couldn't be manipulated or something. Here in the same case also, the date of declaration of NPA could not be manipulated because the date which is declared by the banks, Your Lordship.
Right. Yeah.
This arises a genuine reason, Your Lordship.
Okay. Continue.
Okay. From this, from this, I would like to conclude that the first application, the date of default is error, and hence the applicant has changed the date of default and amended in the second application. So the second application must have been allowed despite an error. That's it, Your Lordship. If the council is satisfied, the council seeks permission to move on with the prayer.
Yeah, of course. Any questions, ma'am? Shraya, ma'am, any questions from you?
Please continue the prayer.
Yeah, continue with prayer.
Where in the lights of the issues raised, arguments advanced, and authorities cited, the petitioner humbly submits that this honorable court may be pleased to adjudge and declare that the second application filed under Section 7 of the IBC 2016 is maintainable, and hold that mentioning the date of default in a Section 7 of IBC is not a mandatory requirement, and declare that the date of default is based on the date of NPA, and hold that a Section 7 IBC petition cannot be dismissed if debt and default are proven and the application is within the limitation, and pass any other order, direction, or relief that it may deem fit in the interest of justice, fairness, equity, and good conscience for this act of kindness. They shall forever pray.
Council, you said it's maintainable. I heard your prayer. But don't you think again, the second petition, if we were to proceed on that, and if the bench is supposed to allow that, wouldn't it be an attack on the NCLAT orders or the NCLT orders that have been passed in this regard?
Yes, Your Lordship.
Wouldn't it be an attack? So how can we uphold that maintainability without attacking the NCLT or NCLAT orders? No, like if you're a counsel tomorrow, you're an advocate, you're telling that this petition is maintainable, but
Yeah.
there's already a NCLT and NCLT order that's been passed in this regard, uh, and they both hold up order. Now, if we are saying that it's maintainable, does it go against the Am I
Your
audible? Yeah.
Lordship. Yes, now you're audible.
Yeah. I was saying, yeah, is it maintainable in that regard, or how do you hold up what the lower courts have already held in a matter?
Your Lordship, the NCLT has mistaken by declaring the second application as dismissed only because the change of default has been done. It is not fair enough to do that. The NCLT should have investigated further onto the matter and should have uh, looked into the genuineness of the case, Your Lordship. It is the
Okay.
error of the It is the error of the NCLT also to not done the investigation properly, because if there is an error in the date of default, the NCLT should have been ensured in the initial cases itself in the
What
inquiry,
was the
but it is not
grounds for
done
the
by the
NCLT
NCLT.
to? What was the grounds for the NCLT to provide an order? It's in the moot proposition.
For the first application, Your Ladyship,
Yeah,
the section 10A bar.
exactly right. Now that's a statutory bar. When a court has passed an order based on a statutory bar and a provision within the bounds and limits of law, why do you think it's not? Why do you think it should be overturned by the higher court right now?
Your Ladyship, we have established that the declaration of non-performing asset is the actual date of default of the case, and not only that, uh, the date mentioned as May of 2020 is a technical error. So
But
if
there's a statutory bar, so how
no,
do you
yes,
surpass that?
I'm coming to the
Yeah.
point, Your Ladyship. So it is established that it was due to a technical error. And if there is a technical error, to rectify it, the NCLT must give 7 days time for the applicant to rectify the error, which was not given in this case.
Okay.
It was
So
dismissed at hand without analyzing the merits of the case, just merely on the section 10A bar, which is unfair.
so does the section 10A bar does the genuineness of the cause or anything supersede the section 10A statutory bar?
Yes, because the actual date of default, as established by the classification of acknowledging the date as NPA, was already established. As
But they
the
kept
first,
changing it as well, the date of default. Initially, in their first application, they had one date, and then when they went before the NCLAT, they changed the date, which the NCLAT recorded and said the banks cannot change at any point. Uh, According to the Wilson Fancy, they cannot change the date of default. A lot of cases
yes,
have also held that.
yes, Your Worship, but this is not an attack on the data, rather than it is a mere technical error.
On what basis? Technical
On
error.
the date mentioning as the time period when the OTS, that is one-time settlement, was cancelled, was merely a technical error, rather than an intention of filing a petition on the basis that the actual date of default occurred during the one-time settlement, whereas the actual date of default occurred when the debt was acknowledged as non-performing asset.
Okay, answer. We'll, okay, you're done with prayer, right? We'll. Ma'am,
Much
any
obliged,
question?
Leadership.
Nothing. I already asked.
We can move on.
Next counsel.
May it please your lordship, I and my co-counsel appearing on behalf of the respondent in the present matter.
You are counsel number?
1.
Counsel number 1. Okay.
With your lordship's permission, the counsel seeks to briefly state the facts of the case.
Yeah, of course.
Public. Your lordship, I shall now take the bench through the brief facts. The facts of the case are the respondent XYZ Private Limited.
I think we can skip the facts. Is that okay, ma'am?
We already heard, no? So
Yeah, we
you can
heard.
skip the facts.
Subject. Your lordship, with your permission, I shall now address the first issue.
Yeah, of course. Carry on.
The first issue concerns whether a second application under Section 7 of the Insolvency of the Bankrupt Code is varied by the law. And the second issue is whether or not mentioning dates of default of the dates is mandatory in application under IBC. And the third issue is whether or not the date of default changes based on facts or is the date of NPA. And the fourth issue is whether or not in the case can be admitted if default occurring and application is within limitation despite error in date of default. As a counsel one, I'll be representing the first and second issue, and my co-counsel will be stating the third and fourth issue. Next, I can, your lordship, whether I can move to the argument at once for the first issue.
Yeah, indeed.
Much obliged. May it please your lordship, the principle of finality and prevention of abuse of process, it is respectfully submitted that the second Section 7 application filed by the financial creditors is buried in law. The Insolvency and Bankrupt Code is a special statute designed for speedy and time-bound designed for resolution of insolvency dispute and respective filing on the same cause of action undermine the obligation of efficiency and convert insolvency proceeding to a tool for harassment. Once a Section 7 section application has been adjudicated and dismissed even on procedural ground, it attains finality and allowing multiple opportunities to cure defects, contraventions, statutory timelines, and procedural disciplines. The Supreme Court in Swiss Ribbons Private Limited versus Union of India 2019 case held that insolvency proceeding cannot be misused as a recovery mechanism or a mean of coercion. Earlier dismissal attracts constituted res judicata, even if the first application was dismissed without examining the merits. It engages constructive res judicata under Section 11 of the CPC as applied to insolvency proceeding. The final creditor had an obligation to represent correct factual foundation, including the true date of default in the first application. The Supreme Court in forward construction company versus Prabhat Mandal 1986 and the Hope Plantios versus Talak Land Abad confirmed that res judicata applies not only in what was decided but also to what ought to be raised through preventing forum shopping and abusive of process. Section 10A IBC bars CIRP application for default occurring between 25/3/2020 and to 25/3/2021. The financial creditors attempt to shift the default data from 2020 to 2014 is a transparent attempt to eradicate the statutory bar, violating principle of estoppel, bona fide litigation, and clean hands doctrine. Default is not continuing. The cause of action is the first filing replies the default. Innovating a continuing default is legally impossible unless the breach is ongoing, which is not the case here. Court have consistently held that reopening settled matters under a guise of continuing default amount of abuse of process. Acknowledge,
On what basis is res judicata being applicable here, counsel?
can you,
On what basis
res
is
judicata will be applicable? That's what ma'am asking.
ma'am, if a court has already given the judgment and once again we can't able to propose the same judgment in the same court now.
right, but why is it applying in an IBC proceedings? Does the CPC supersede IBC proceedings, or what's the applicability?
Ma'am, and the count is 6 ignorance, ma'am.
Pardon, counsel?
The count is 6 ignorance.
Okay.
How many OTS proposals has been filed by the respondent? How many one-time settlement proposals has been filed by the respondent? And how it makes impact under IBC?
Can your co-counsel answer the question? Any one of you can.
Council seat ignorance.
Okay, but
Okay. So you proceed.
Yes, ma'am. Your Lordship, with the permission, I now advance argument on issue 2.
Yeah, of course.
That's okay. Whether or not mention mandatory requirement of default data, Rule 4 and Form 1 of the Insolvency and Bankruptcy Rules 2016 explicitly requires the mention of the exact date of default. The default date is jurisdictional fact necessary to determine limitation and acceptability of Section 10A. The Supreme Court in Balbal Varadaraji versus Veer Gujarat Aluminium Industries Private Limited 2020 held that the application without the correct default date is incomplete and not maintainable.
which court had pronounced the judgment, counsel? The one you just stated.
Yes, ma'am.
Which court pronounced the judgment?
And the Supreme Court,
The Supreme Court.
yes, ma'am.
What's the name of the case again?
Babulal Varadaraji Gujarat versus Veer Gujarat Aluminium Industries Private Limited.
Okay, sure. Thank you. Proceed, Council.
Mr. Topral, the financial creditor initially mentioned the default as 1/5/2020. It's during the COVID suspension and now seeks to alter it to 1/4/2014, such as contemporary stances constitutes abrogation and reprobation bearing under Karam Kapia versus Lal Chand Public Charitable Trust 2010. Res judicata bars second filing. The NCLT dismissed the first application affirmed by NCLAT. The findings regarding the default date, and Section 10A attained finality. Per absolute bar under Section 10A. The Section 10A provides an absolute prohibition for default during COVID-19. Ramesh Kaimal versus Siemens Gamesa Renewable Power Limited 2021 case confirmed that this bar is permanent and cannot be terminated. Certainty of default date is essential. The insolvency of process is summary in nature and adjudicating authority must determine whether a default occurring within limitation. The legal maximum certum est quod certum ready pros. This is certain which may be made certain undergoes the uncertainty regarding the default date vitiates the application. And the conclusion for issue 2 is mentioning the correct date of default is mandatory. Attempting to change it to bypass Section 10A renders to application non-maintainable and is an abusive of the insolvency process. With your lordship's permission, I shall now conclude my submission.
I just have one question, Council. You said the date of default has to be mentioned, and what if the date of default is a continuing one? How do you determine a specific date as a date of default? Should there be a specific date?
Yes, ma'am.
Yeah, but what if a default is continuing? How do you determine a specific date, or how is a court supposed to determine a specific date in that case?
Ma'am, after 90 days, the court doesn't have, if they don't daily.
So in 90 days time will be given, right? In case if they won't pay back, then it's gonna come under non-profit asset.
90 days under what provision, Council?
Section 7,
Of?
Insolvency Bankruptcy Act.
So that's Section 7, is the initiation of CIRP proceedings, right?
It tells that in case if the person doesn't pay back to the financial debtor, then it's gonna there'll be 90 days time, and in case if they won't pay back, then it's come under non-performing asset.
So is it all about existence of the default or the accuracy or the specification of a date that is more important? What is more important for initiating a CIRP proceeding under Section 7?
Date of default is important so that they don't misuse and there will be transparency involved.
Which part of the provision mentions that, Council? That date of default is it expressly mentioned in the provision itself? Section 7.
Yeah, it's mentioned under Section 7.
Under what clause? Which part?
council city limits.
You just said it's there.
And then it's mentioned as when I do, but I do not know which clause.
Council, you're stating a provision before the court. We cannot seek ignorance, right? For this, you're stating a provision. What's your understanding on the Section 7 provision?
If the money is not being paid back to the financial creditor, the 90 days time will be given. In case it's not paid back, then it's going to come under non-performing asset. Then,
Right.
and there's also involving like there should be a transparency and it should not go against jurisdiction and judiciary aspect.
Right. Now, does it provide for a date of default? 90 days, right? From when? 90 days of from when? At what point?
From the first default.
So that is an existence of a default or an accuracy of a date? What do you think?
I think accuracy of data.
It's an existence of default, counsel. Since when the court determines there's an existence of default, from that time 90 days will pass, right?
Yes, yes.
Because accuracy of the date, then in your case, in any case, the date will keep changing before the courts. So how does the court determine that? Would it be an accuracy of date or would it be the existence of a default?
Existence of the date. As it was during the COVID time, so it's like there was a law passed that it's, whatever the matter has taken place related to the default thing, it should be temporarily hold.
Right. So
And
on the basis of that, yeah, you can continue to your prayer. Let's listen to that. Ma'am, any question?
Nothing, nothing.
Therefrom, the light of the issues raised, arguments advanced, and authorities cited, may this honorable court be pleased to gracefully consider, adjudice, and declare that dismiss the appeal as non-maintainable due to the errors and misleading date of default. Hold that the statutory bar and judicial defaults prevent initiation of writ in the present case and pass any order them fit in the interest of justice. Pass any other order as them fit in the interest of justice and equity, and for this act of kindness, the counsel for the respondent shall be duly bound forever.
What's the direction you seek from this court?
The first issue. The first issue mainly we seek is that once a Section 7 application has been dismissed, even for the technical grounds, filing it again is not allowed by the law, which can avoid misuse of insolvency process and ensure like cases can be more quickly done. So when it comes to issue two, when it comes to crucial date, it should be mentioned because it's going to affect whether the application within the legal time or not, and whether the COVID-19 protection applied or not. So when it comes to issue three, default date should be like the date when the loan has been clarified should be mentioned as a non-performing asset, which where the system like no one can take a misuse of the system aspect. So when it comes to issue four, filing false or wrong date not allowed. But because when it comes to serious, it's going to create a serious error in the justice, and which will prevent transparency also.
What's the direction you're seeking from the court? What do you require this court to pass a direction on?
Um, so we request that it is going to be repaid, but the thing is that it cannot be reapplied again, the application.
You're saying there should be a bar on the reapplication of.
Yes, repeated.
Anything?
Nothing.
Court master, are we done with both sides? Do you want to?
Thank you, Your Lordship, for your time and efforts. If Your Lordship allows, we will stop the recording.
1 minute. Ma'am, do you want them to do a rebuttal round?
Yeah, of course, we can allow them, no? We can allow.
Yes,
Okay.
yes, we
Rebuttal,
can.
sir,
For
rebuttal, we can allow that.
Uh,
45 seconds rebuttal
okay.
on the discretion of the.
TGA 39, I think you can make 1 point for rebuttal, and then the other side can rebut it. That's all. One rebuttal point we can allow probably as per the time.
We can go for rebuttal.
Councils, TGA 39, I think. Am I audible?
Yes, your leadership.
Do you want to rebut to any point of this?
No, your lordship.
It's a rebuttal round. You have to.
If that's the case, I would ask on what basis the second application has been not allowed from the filing.
They've already made their arguments. It's not about a question. You're supposed to say what point of this you don't agree with and why it should be like that.
No, your lordship. We don't have any.
Okay.
Any sir rebuttal? Second team, any sir rebuttal you need? Against the rebuttal, what do you want to say? Anything?
There's no any argument which has to go against them. But there's one particular thing when it comes to reapplication. Again, I'm repeating that they cannot apply again.
Okay, you said your point. Okay.
TJ 39, you want to respond? Councils? Councils, am I audible? Are we in the court?
Sorry, your leadership. I couldn't operate my system.
Did you hear the question the other councils had presented?
I think they didn't asked about a
Oh,
question.
no,
They
they
said that
didn't.
the application couldn't be filed again. That's
Right.
it, your lordship.
You
But
want to respond to that?
only I would like to conclude with the point that the application has not been closed on the basis of the merits, your lordship, your ladyship. So the second application could be admitted in the court.
Okay. Oh, but why?
Because the application has been dismissed without any further investigation, just because the default has been made on on the I couldn't remember the exact fact, but the dismissal has been made just because the date of default has been changed.
On technical grounds, as you
It
have
is not
stated.
fair.
Okay. Sure. Thank you, councils.
Thank you.
So let's wind up now.
Yeah.
Thank you,
So
Your
all the
Honor,
best for your,
for
it
your
was very
time.
good session. All the best for your all future endeavors. Happy to meet you, Sraya ma'am. You are from Telangana, no?
Yes, ma'am. Yes, ma'am.
You are a practicing advocate.
Yes, ma'am.
Happy to meet you.
Happy to meet you too, ma'am. Thank you so much for sharing the bench today.
Yeah, of course, of course. So anyway, we can wind up.
Can we give feedback to the?
Yes, after this recording can be
Oh,
stopped. Judges can give the feedback.
Yeah.
Please stop recording.